Good afternoon. May it please the court, Tom Pabst on behalf of Kevin Smith, appellant. If it's okay with the court, I'd like to save 1 minute.
Yeah, would you wait for a moment until we clear the courtroom?
Sure, of course. Pretty much did clear the courtroom there, didn't it?
Okay, please proceed then.
Okay, thank you very much. Tom Pabst on behalf of Kevin Smith, police officer in the city of Flint. And if it's all right with the court, I'd like to save 1 minute, for rebuttal.
Could you please elevate the podium a little bit? Do you see the controls that are underneath there?
No. Under the podium.
You can lift it up.
Oh, you want me to raise it?
Yes.
We do need to highlight that.
Okay, thank you.
Thank you.
Lucky I got this far. I'm not mechanical. I don't rely
Either that
on
or
my
we have to
son.
lower the floor.
Pardon me?
Either that or we have to lower the floor.
Okay, how's that?
That's great, thank
You
you.
hear me okay? All right. The court asked me to address 3 questions, okay, in this case. First of all, was it a mistake to apply the ruling in Pena to the Whistleblower Act, okay? Absolutely it was. Absolutely a mistake. Never should have happened. And I say that because the Whistleblower Act is supposed to remove or diminish or eliminate barriers for whistleblowers to bring a cause of action, whereas Pena imposes an ultimate employment action requirement on whistleblowers, which raises the barriers. I know this is the law of Michigan because this was the holding in the Whitman case, where I was privileged enough to argue before you in November 2012. Specifically, on page 312, this court ruled the Whistleblower Protection Act furthers this objective of providing protection for whistleblowers by removing barriers that may interfere with employee efforts to report and by giving them a cause of action. So the whole idea...
I think you need to speak before the microphone so that we can record what you're saying.
Yes, sir. Yes. So the whole idea of the Whistleblower Act is to eliminate barriers, not create them.
Counsel, that part of Pena, the Court of Appeals did not apply. Isn't that correct?
No, they held that it was an ultimate employment action requirement, as I read it. So if that was the first question I was asked to address.
I disclaimed that part of Pena and recognized that the United States Supreme Court had done so.
Yes, in a Title VII case, they did so. The Sixth Circuit en banc.
No, I'm talking about the Court of Appeals here, in this case, did not rely on that part of Pena. Is that an accurate statement?
Oh, I thought they did apply Pena, the ultimate, that it has to be ultimate employment action. That was the ruling of the Pena case. Am I mistaken on that? That they
You make your own argument.
Okay, all right.
I thought they hadn't, but...
Well, the problem is...
Sir, I thought that the emphasis of the Court of Appeals was on the objective and material standard provided by Pena, not the understanding of what constituted an adverse employment action. So there was reliance on Pena, but not for that proposition.
Okay, well, if that's so, then I think the Court of Appeals, with all due respect to it, violated the mandate of Marbury versus Madison, which is that a judge's role is to interpret the law as it is, not rewrite it, not add terms, not take terms out, as it ought to read. Okay.
But how is that particular standard in Pena materially different than the white standard of how is that?
Then the white
Where's
standard.
the big Marbury violation here?
The Marbury violation is that the express text of the Whistleblower Protection Act statute says that it is unlawful and it gives rise to a cause of action, an adverse action, to threaten a whistleblower. Number one, threaten. That is not an ultimate employment decision. And secondly, to change the location in retaliation for someone blowing the whistle. Okay, not significant location. It says location. Okay, so Marbury versus Madison would say you interpret that statute as it reads. you don't add in an adjective like significant that can mean many different things to many different judges.
The question I thought that we were focusing on is a proof question. What is the nature of the proof, whatever the retaliatory event is, whether location
Yes.
or otherwise? Doesn't an employee have to have some quantum of a belief,
Yes.
a reasonable belief, or what? There are different permutations. That's what the Court of Appeals was focusing on, not the other part of Pena.
Okay, I was asked to address three questions. Number one, was it wrong or a mistake to apply Pena?
Well, but you're applying the part of Pena that the Court of Appeals rejected. So I'm asking you to talk about the part it did apply. What was wrong about that?
What was wrong about it was threat and location do not appear in the text of ELCRA. Pena interpreted the Elliott-Larsen Civil Rights Act. The Elliott-Larsen Civil Rights Act does not contain the word threat as an adverse action, and it does not contain the word location as an adverse action. The Whistleblower Protection Act does. And so applying Pena...
We're talking about retaliation.
Yes, we are.
And a report of retaliation. Whatever the acts of retaliation, let's put those aside for a moment.
Okay.
What does the employees, the whistleblowers' state of mind is required under the WPA?
There is no state of mind. As a matter of fact,
So a
that's
lie
exactly
is
what...
sufficient. I don't have any possible belief that there is a actual violation of law or a threatened violation of law. That's sufficient. And if I make a false accusation, that satisfies the WPA.
No, a false one does not. That is the one exception. If you knowingly false, no protection.
Why? Where does it say that?
It says that in the statute, in the Whistleblower Protection Act.
I'm sorry?
It says that in the Whistleblower Protection Act statute, MCLA section 15.362, unless it's knowingly false. If it's knowingly false. But I can remember, and as a matter of fact, you decided my Whitman case, which was one of the proudest moments of my life, and you said, who cares what his motivation is? Who cares if he wanted to? As a matter of fact, Justice Young, I remember you saying it. The word you said. Yeah, go
I don't
ahead.
remember you saying that.
Counsel, can I ask a question?
Sure, yeah, of course you can.
We're here, it's a C8 motion, so we're not really on the proof side, we're on the allegation side. But what's the law violation or suspected law violation that your client is alleging in this case?
The same law, thank you for that question, the same law violation that existed in DeBono Griffin versus Lake County, where people governmental officials get money under a millage and then they misuse it for general fund money.
Is there a law that says you can't take money that you raise in a millage and deposit it in the general fund?
Yes, there is, and I cited it in my brief. It's MCLA 449. I don't have my brief, but I cited it in my brief. It's an MCLA statute that says misappropriation of money. It's the same law violation involved in DeBono Griffin versus Lake County that this court decided.
I was having trouble isolating the statute. They were finding that in the statute that you're referring to, so I'd appreciate it if you could be more specific.
Okay.
Is it 750.490? Is that what you're pointing to?
Yes, that sounds like exactly it. I didn't bring the brief up with me, but that sounds like exactly it. I did cite it in my brief, two statutes. It's the same law that was allegedly violated in DeBono Griffin. But you know what, even if...
Isn't the argument, though, in some relevant part, whether you should have been afforded an opportunity to amend your pleadings?
No, I don't think there's, unless you're going to impose a heightened pleading standard and require the exact violation of the law to be put in the pleadings. As I understood it, practicing for 40 years, that's not a requirement.
So you think concerning the subject of what was involved in the alleged whistleblowing, you have satisfied that element, and it's not that you're seeking additional opportunity to clarify or make more explicit what you would like to assert?
Not unless you think that it's a requirement, and then I would ask for leave to amend it. Yeah, but I don't think it's necessary. I think I did set it forth very specifically. In particular, paragraph 21 of the Third Amendment complaint, which I attached as Exhibit 3, very specific that we alleged a threat. a threat against Kevin Smith for raising the issue that the millage money is being misallocated and also impound money is being misallocated. Paragraph 21 is clearly he was threatened. It says that, in fact, there came an occasion when a meeting between the emergency finance manager, Ed Kurtz, and found the attorneys were there, the HR manager, and the union attorney was there, and Kevin Smith were in a room when John Clark said in the presence of everyone, quote, "Your union president here better watch what he's saying in public about these monies. He shouldn't be saying stuff like that." And then he threw a book down.
So did I interrupt you in the course of responding to Justice Viviano's question concerning what the law at issue was here? How did you respond to that again?
I say it is a violation of the law, and the MCLA 750 to 400, I don't have it right in front of me, but it's in my brief.
But you don't have to be accurate about that. And
I'm sorry, what's that?
That doesn't have to be a legally accurate thing, right?
Yeah, I know that.
All you have to do is plead
Yeah.
that you believe there was a
Yes.
legal violation.
Yes, that's true.
Whether that's true or not is not material at this stage.
That's a true statement. As long as he reasonably suspected a law was being violated, that's enough.
But I'm kind of curious about that point, because you don't have to know that it was a violation, but isn't the thing that you either knew or didn't have to know, doesn't it have to at least theoretically be possible that it could be a violation?
Yeah, but he reasonably...
In other words, you have two things here. You have, I think, as I understand your theory, on the one hand, that the money was put in the general fund, and you believe under this statute that happens to be in the MCL book somewhere, that it has to be segregated. That's one thing, right?
Yeah.
And the second thing you say is that it, not only was it not segregated, but is your client also alleging that he believes money was spent for general fund purposes?
Yes. And as a matter of fact, he told...
How can he tell, like, I'm conceptually having a hard time with that theory. So was the general fund, because the money presumably is fungible, right? The money that comes from, if it's combined, unless the general fund was zero, how does he know how the millage money was spent versus the other money that was in the general fund?
Because the millage money, everyone advocated it as it'll provide 30 new police officers on the street. Well, it didn't. It provided 5.
Well, but it also said police or fire, and it wasn't restricted to only hiring employees, I think. I mean, why is it that your client believes that he had such a clear understanding of the purpose of this? Was it the language of the millage proposal that said, if you approve this millage, voters of Genesee County or city of Flint, then we will hire 50 police officers? Did it say that in the millage language?
I think he discussed it with the chief of police and with the lieutenant or the Captain Patterson. I think that they agreed with him, that the money was put in the general fund.
Isn't it what the voters voted for, or is it what the chief?
That wasn't what the voters voted to put police on the street, 30 of them.
Why did they include fire in the millage?
I'm sorry, what?
Why did they include fire? They're so only interested in police. Why did they, wasn't it a police and fire millage?
Yeah, that wasn't the only sum of money. There was also impound money from impounding the cars that wasn't being used to put police on the street. So he complained about that too. In fact, he filed a complaint about that.
What I'm trying to understand is, maybe your client has a First Amendment claim because he was out there making political statements about how money was being appropriated and spent in Flint. But that sounds to me something different than a claim that a law was being violated, unless you can tell me what law was violated, in which case I'm happy to consider it. That's why I'm trying to be specific. But it sounds to me more like your client politically didn't agree with decisions that were being made. Are those two different things, or in your mind, or are those the same thing?
I don't know. I guess they could be two different things, but I don't think that's the standard. I think the standard did he reasonably suspect that a law was being violated? He did.
Suppose he believed that the city fathers were supporting a Mars mission, in violation of statutes,
Sure.
Ordinances that require the city to spend only on city.
Right.
Would that be a valid WPA claim? Would that
Comes down to a question of reasonableness. Did he reasonably suspect if it's a Mars mission? I don't know. I guess that might trigger that. Is that a reasonable suspicion? How could he believe that?
I'm trying to nail down in my own mind how accurate the suspicion of law breaking has to be?
Statute provides it should be a reasonable suspicion, or at least it's been interpreted that way, a reasonable suspicion.
Well, it can't be a frank lie.
That's right, I agree. That's the exception.
Shouldn't it?
It can't be knowingly false.
It can't be knowingly false, but can it be unreasonable otherwise? It's not knowingly false, it's just unreasonable.
I think
City fathers are funding a Mars mission with dedicated tax dollars.
it strikes me that's a jury submissible issue, isn't it? I mean,
Really?
whether it's reasonable or not. Yeah, I think that's a jury submissible issue. Unless, where's the evidence that it's knowingly false? I haven't heard anyone say anything in a brief that he knew it was false. Maybe I missed it.
So
I don't-
falsity is the only limitation.
No, reasonable is but it's a jury question, not a judge question. I mean, look, either you want people to have the courage to come forward and risk their whole livelihood to do the right thing, knowing they're going to be protected, instead of wondering, I mean, what's the message to the whistleblowers here? That everything's going to be fly speck like this? Like if he says, I tell you, they're ripping the money off. They promised they put 30 police officers on the street and they put 5. I talked it over with my superiors and they say, yeah, that's right. It went in the general.
Isn't the whistleblower law supposed to, I mean, when you say it like that, it seems to me, how is your client in a how is he uniquely situated because of his employment to know this? In other words, isn't what you're talking
He's the president of the union.
Isn't what you're talking about all publicly knowable facts by everybody in the city of Flint?
No, it's not.
So your
He's the
client's the
president of
only
the
one who
union.
knew the purpose of the millage, or he's the only one who knew how those expenditures were made, even though that was all public information? Your client, because of his position, was uniquely situated or learned information?
I think he was uniquely situated. He talks to the chief of, people on the street don't talk to the chief of police. They don't talk to the captain. They don't talk to the HR manager, Erica Hunter. Kevin Smith did. So yeah, he did have unique information. Yes, he did. He did have inside information. And many of the things that he believed were confirmed by the captain and the chief. We pled that. What more do we need to be a whistleblower here? I mean, he was threatened. We alleged it. His location was changed to a bombed-out part of Flint that looks like Aleppo, Syria. And not that he's afraid to go up there, but it used to be on rotation, and all of a sudden now it's not on rotation. He used to be the president, but now all of a sudden he can't be the president of a union.
I think your time is up, Mr. Patch.
Okay.
Appreciate it, though.
Sure.
Mr. Kim?
Thank you, Mr. Chief Justice, and may it please the Court, Assistant City Attorney William Kim on behalf of the appellee, City of Flint. The city would argue that the Court of Appeals arrived at the correct result here. The Court of Appeals properly followed stare decisis and applied the standard of proof that was set forth in Pena versus Ingham County Road Commission, which, as set forth in that case, is applicable to all whistleblower and anti-retaliation claims, of which this is clearly one of them. And concluded that the Court of Appeals concluded that dismissal by the trial court was warranted on different reasons than the trial court had decided, but on 2 separate grounds. The first being that the plaintiff failed to allege a protected activity and failed to allege that he had suffered an adverse employment action that was both materially and objectively adverse. If this court agrees with the Court of Appeals on either of those two findings, then the dismissal is proper and it should be upheld. And I waive my.
Well, let's dig in then. What do you believe that the change of duties that includes a location in apparently a bad part of Flint is, as the Court of Appeals described, not cognizable under the WPA as a retaliatory action?
I think what we have to look at here is the material and objective standard that's been adopted by Michigan courts and by federal courts as well. And that looks at whether essentially the action that was taken is something that would that would dissuade a reasonable person, you know, a reasonable employee from reporting misconduct.
I think most people on the force would take notice that if they open their mouths, they get consigned to the most dangerous part of Flint. In the graveyard shift and without recourse, I think that probably sends a message, don't you?
I would disagree, because any officer can be assigned to.
Well, wait, counsel, any officer, but that's, I mean, I think what Justice Young is getting to is a really important issue. You were going to say any officer, but wasn't he the only officer that was assigned to that area? Everyone else kind of rotates, but he was specifically assigned to that area, was he not?
I believe he was. At that time, he was the only officer who was assigned to patrol the north end, but obviously this is an early, this motion was filed in an early stage of the case, and so.
He was but let's hold on for a second. He was the only officer that was assigned to that specific area, correct?
That's my understanding, yes.
Okay.
While the others rotate.
The others assigned to patrol, yes, they would.
Okay. You said this is early stage.
Yes.
Okay, yes, this is a pleading stage. Why isn't that sufficient to withstand a C8 motion?
Well, that alone is insufficient because independent of the allocations of whether or not he suffered a retaliatory act, he also had to engage in protected activity.
Well, just a moment. We're just talking about whether the retaliatory act alleged here is sufficient. And I'm suggesting to you that if it is alleged that the officer was assigned uniquely to the graveyard shift, no other officer was, why isn't that at least facially sufficient pleading to survive on that one issue, a C8 motion?
I would set forth two reasons, Your Honor.
Okay.
First, at the time, he was the only person who was reassigned from the police headquarters to patrol. So he's essentially, in a lot of ways, a case of one.
Yeah, except that when they told him he was going to go to patrol, they told him he was going to work a day shift. It turns out he worked a graveyard shift in the worst part of the city. So you don't. I'm just saying. I don't know whether it's all how in the wash. I'm just trying to look at this on the surface, as you do on a C8 motion on the allegations, and I'm hard pressed to understand how we get to go beyond those pleadings to say there is no jury submissible question on, or those don't establish sufficient allegations to survive summary disposition on the retaliation, leaving aside whether he engaged in protected activity. And I'm offering you an opportunity to explain to me why on that claim, that part of the claim, doesn't survive.
Well, the other argument that I would raise is that essentially what we're talking about is a reassignment of the plaintiff from a position that was eliminated prior, and it's conceded that it's prior to any report of any potential report of illegalities.
But this isn't just alleged to be an assignment you put in the general rotation of cops. This was a specific assignment unique to him. That's what's alleged, right?
Well, what's alleged is that he was reassigned to the patrol division, assigned to the night shift, as are roughly half of the patrol division.
But they're unique. They pled that there were unique features of this assignment, right?
My understanding is.
Let's go to the other one.
Well, actually, I just want to ask. It seems like this assignment, if I was to look at this, or at least a jury could look at this, could they not look at this as though this seems to be kind of uniquely tailored for this person? Seems like it was kind of crafted just for this person.
Insofar as obviously that the plaintiff received a specific assignment, it was obviously tailored towards the plaintiff.
This individual person that he was going to be working these hours, this shift, everyone else rotates except for him.
Well, in terms of rotations, officers do not rotate between, say, the day shift and the night shift.
No, we understand that. We get that. We're talking about the location. It's that this is a very specific location, and you are going to be doing this, but everyone else rotates except for you.
That's what was alleged.
That's what was alleged, and I would say that there's also a legitimate reason that the police department could want to focus efforts onto the north side.
I mean, now you're in a different, you're not in C8 land anymore. Talk to me about why what was alleged here as the protected activity doesn't establish a cause of action.
Certainly. Essentially, the allegation that was made, the allegations that were made was that the protective activity was that the plaintiff complained to various city officials, superiors in the police department, that
So one,
millage funds.
he made an allegation to the statutory authority.
Yeah, we can see
Check that box.
that box is checked. Okay. However, he had to report a violation or suspected violation of law. Okay. What he reported was that the millage funds were being used, that they should have been used to hire additional police officers. They weren't being used for that purpose, and so that was a violation of law, according to the plaintiff.
I understand that's what the Court of Appeals said, but the Court of Appeals sort of left out a little bit of what the plaintiff alleged, right? In his third amended complaint, paragraph 18, he says this: "It was the plaintiff's strong position that he voiced it to the public, the press, Chief Locke, and Captain Patterson that a large portion of that $5.3 million in millage money supposed to be used to hire new police officers was in fact put in the general fund for use and payment of regular bills for the city of Flint, not police protection." So he said a little bit more than the Court of Appeals acknowledged.
So it was put into, yeah, that's correct.
And is it your view that would violate the General Property Tax Act if in fact that was happening?
Well, it depends on what the city's general fund funds approximately 66% of 66% of the general fund is dedicated towards police and fire services.
Just go back to my specific question is, do you concede that if in fact that allegation was happening, the millage funds were used for a non-designated purpose, would that amount to a violation of law? Or does at least City of South Haven, our case, say it does?
If it was used for a non-designated purpose, that would be true. However, in this case, the designated purpose of the...
Stop.
Yes.
Now you're going into facts. We're talking about allegations at this point. If the allegation is, as just read to you,
which doesn't appear in the Court of Appeals opinion, but appears in the plaintiff's complaint.
You must treat that as a true allegation at this point, right?
Right? Only if it's a
C8.
Even under a C8, if an allegation that is clearly factually untrue does not have to be accepted by the court. And in this case, the Court of Appeals looked to the language of the millage itself. And the language of the millage itself sets forth clearly that the purpose of the millage is to be used for police and fire services generally.
Yeah, but the allegation here is that it was being used, the allegation says it was being used to pay the regular bills for the city of Flint. The regular bills for the city of Flint probably are not police and fire, at least reading the complaint.
The regular bills for the city of Flint are police and fire because...
They include them, but they're not necessarily...
They're more than that, aren't they?
But then it goes on and says not police protection.
Yes, the Flint has other bills.
Oh, I thought so.
And so even if this is right, so you didn't raise this question before the Court of Appeals, right?
I believe that the court, that portion of the court raised...
And so, you know, probably they shouldn't have done that. And even if C8 is properly granted here, shouldn't the plaintiff be allowed to amend his complaint? Isn't that the relief? Isn't that what our rule says?
Well, this case is somewhat strange in that the motion predates discovery in a lot of ways, so that there's still even if the Whistleblower Protection Act claim, the dismissal of that by the Court of Appeals is upheld by this court, there still remains several other claims that will be dealt with in course that are essentially unaffected by the disposition of the Whistleblower Protection Act claims.
Tell me what your theory of a C8 motion is. What does it test?
Well, a C8 motion would test whether or not the plaintiff has alleged a claim on which relief can be granted, essentially.
Right. So, and all the allegations are to be treated as true, correct?
Allegations are treated as true. However, a clearly incredible allegation does not need to be accepted by the court.
Well, tell me what is incredible then and incapable of belief, alleging that funds that were restricted by the millage to support fire and police were being used for non-fire and police purposes in the general fund.
What's incredible about that is that essentially the general fund far exceeds.
I understand that it's their entire budget. This is not suggesting, this is very narrow. It's saying the millage is supposed to support two things, and the city of Flint is not using them for those two things. Do you disagree that that's what these allegations say?
What the allegations were saying was that the millage funds could only be used for certain purposes, and they were being deposited in the general fund and then not used for the correct purposes. However, once it was deposited in the general fund, the funds were being used to support police and fire services.
You're going to win at trial.
You'll win as a fact. But at this point, he's saying that's not true. Isn't that what he's saying?
If you're right about the last part of what you just said, then you can prove that up at trial.
And you're going to win.
Or maybe it's a C10 motion.
Or maybe it's a C10.
Yeah,
but right now we're on C8.
Does presumably Flint's expenditures out of its general fund, that's public information, right?
That is correct, Your Honor.
So this would not be information that you would have to work for the police department or talk to the police chief to know, right?
No, the city's budget is.
And I'm not suggesting that's a requirement under the Act, but the question I have from a pure pleading standpoint, is this allegation too conclusory? In other words, is it okay to say, I think there was a law violation because I think the money that was deposited into the general fund, some of it may have been spent for other than designated purposes? Or do you have an obligation, even at the pleading stage, to say, because it's information that's publicly available, to allege the money out of the general fund, this money, somehow you could trace it. I mean, I'm trying to think conceptually how you can do this since it's fungible. But say the general fund was zero, I guess, and then you got $5 million into it, and then you could say they bought a library book, and so therefore they've violated the law. And do you have to allege that? Do you have to allege some theory that I can follow in my mind as to how this would be?
I think you would have to allege sufficient facts to, establish the bare bones elements of the claim. And here I don't think that the plaintiff has done so. The plaintiff.
So then he gets to
amend,
right?
I don't think that I could, I don't believe that I could strongly argue that he shouldn't be allowed to amend unless essentially any attempt to amend would be futile.
Okay.
You normally would say, then don't. What happened?
He's not a middle chair anymore.
Oh, he's not a middle chair.
Okay. Thank you, counsel.
Thank you.
Mr. Pabst, you don't have any time left, but I would like to ask you one question. Maybe my colleagues have something else they'd like to ask.
Yes, Chief Justice, sure.
Do you still want to stand on your assertion that there's no reliance in your argument upon the fact that you were denied an opportunity to amend in this case? You resisted that when that question was presented to you.
No, I think that if somehow, some way this pleading is defective or somebody rules that it is, and in my heart and mind I don't believe it is at all, I would ask for an opportunity to amend the pleading, sure. Of course I would. But could I say this?
Well, you didn't about 10 minutes ago.
Pardon me?
You didn't about 10
Oh, well,
minutes
then I'm glad you asked that then, because, yeah, we would like a chance to amend it if somebody says that it needs to. I would like to point out the last sentence, though, I think might be informative, given all the questions that I've been asked here. Look at the last sentence of paragraph 18 of the third amendment complaint that Justice McCormick read. The last sentence is after that the millage, $5.3 million, was supposed to be used to hire new police officers, was in fact put in the general fund for use in payment of regular bills for the city of Flint, not police protection. Captain Patterson actually agreed with this statement. So, I mean, you talk about mission to Mars and such.
That's
I mean,
sort of beyond what you were asked.
okay, all right, thank you.
Does anyone else have any questions?
Anyone else have a question?
Okay, thank you, Mr. Pabst.
Thank
In
you.
this case.
Thank you very much. The last case we'll hear this afternoon is People versus Darius Franklin.